Distinguished council members, our erudite lead speaker, Professor Taiwo Oshipita, SAN, distinguished participants drawn from the Nigerian Institute of Advanced Legal Studies. Good morning to all our guests that join us from the judiciary, from the private bar, from the academia, and also from the civil society, from both within and outside Nigeria. You are all welcome. Without wasting much of our time, we would like actually to go straight to the point. We will give our council members an opportunity to intervene in five minutes, but we would like them to bear with us. Let's give the floor first to the lead speaker, and I'm sure Professor Taiwo Oshipita would like to speak actually for 35, 40 minutes, maximum 45. Prof, how many minutes do you need? And the topic is the search for a fiscally autonomous judiciary in Nigeria. This has been a very contentious issue in the last actually few weeks, and it's been actually a debatable actually point in the last 2-3 years, despite the existence of the constitutional alteration to that effect. And I think fiscal autonomy for the judiciary at the federal level is not a problem, but it is a problem when it comes to the actually state judiciaries. And I think this is an area where we are trying to provide a sense of harmony. And I think the title actually is apt. Prof, thank you for choosing the title actually for this webinar. So Prof, we would like to give you 40 minutes. If it is too much, let me know. The floor is yours, Prof. Distinguished Professor, SAN, Professor Taiwo Oshipita. I think this is actually a very excellent presentation, and the analysis are very apt. And I think it's good that you challenge almost all of us, and then you also provoke our thoughts to see the other side actually of the story of the judiciary in Nigeria. And I think one clear fact has to do with the status of our magistrates who handle almost 60-65% of the cases, and yet practically they are treated as non-judicial officers because they are not actually defined, as members of the course of the superior course of record. And I think that has really made quite a number of actually magistrates across the federation to be, voluntarily leaving the service. Many of them have joined civil society organizations that I know of quite very well. Very brilliant, active chief magistrates, abandoned actually the judiciary because, since actually the 1990s and the 2000s, they have made their case under the association. They've engaged state CJs at several fora in the last 20 years, to the best of my knowledge, and yet their case have not been heard, and nobody has pushed for their actual cases. And I think this is actually one of the issues that are very thorny that we need to actually make, a loud voice on and see how strategically it can be actually addressed. I would like to open the floor for first our council members to take the floor for a minute or two each before we ask our discussants in 5 to 6 minutes to discuss the presentation. Council members, in no particular order, the floor is open for just a minute or two intervention.
Appreciate the lead speaker.
Your name, please. Once more, your name. Next council member that is actually ready. The floor is open. One open. Yes. Yes, the floor is open. Deans of Law, Enugu, Abuja. Yes, Dean of Law, UNN Enugu, Dr. Nwatu, please. Yes, we can hear you. Go ahead. Thank you, distinguished Prof. Leonard Silk. I think we need to draw the curtain at this point, and we would like to first appreciate council members for taking time actually to make their interventions, and also for the lead speakers, energy in responding to most of the interventions actually made. We would like to also thank our participants for their time and energy and for their patience for almost 2.5 hours, or 2 hours and 40 minutes. We planned to stop at 1 o'clock, but it's been extended to almost 1:40, sorry. And I think we've had a very fruitful actually discussion, and we assure our participants that we'll package our webinar proceedings and then tease out some policy briefs and recommendations that we can send to the appropriate policy and decision makers on this particular issue, particularly NJC, MBA, Office of the Attorney General, and then Attorney General's Office, etc. Thank you very much. Dr. Irekpitan or Dr. Nkiruka, the floor is yours for vote of thanks in 1 minute.
The various universities who have joined us, our other attendees from the bar and the bench, and our NIOS professors and members of staff. Thank you all for being here.
Yes, we can see you all. More, we need more, yes. All right, yes. Suleiman Idris, we can see you. Okay. Please, NTA is covering. So, NTA, have you gotten them? All right, so thank you all. Thank you. We've gotten you all. We are grateful. Thank you. Bye-bye. In the first instance, this is a very good question. We are very much aware of the fact that there was actually a judiciary staff of Nigeria's actually strike that lasted for almost 74, 78 days. Practically, you can say 2 months or more. And it's all about the need for judicial autonomy, at all levels of governance. Particularly in theory, we were made to understand that this independence actually exists at the federal level, but the testimony actually of judicial officers at the federal level, particularly the CJN, as referred to by the lead speaker, indicates that financial autonomy wise, the judiciary is still in bondage in Nigeria, and that is because if you look at their package, against inflationary trend, and compared with other jurisdictions, even though some of the jurisdictions actually use in the lead presentations actually, today, may not necessarily reflect, the context, of Nigeria with other peer group countries. But it goes to show you that, if a whole appellate court judge or a CJN, receives an alert of not more than 800,000 naira, per month, if you set it against inflationary trend, as at today, it's almost reduced in terms of value, for money, by almost 100%. So it comes down to almost 400,000 naira per month. I don't think any one of us actually believe that that's the salary actually package of the head of the judiciary, of the entire federation. It's very ridiculous. And if you really want to fight corruption in the judiciary, I don't think that should be the kind of take-home, package for such appellate court justices or for such heads of judiciary. It is very ridiculous and it makes no sense at all, even in the fight, against corruption, in any sector, particularly in the judiciary. And if you also set it against why the judiciary staff of Nigeria went on strike, JUSUN, went on strike, it's also about, autonomy for the state judiciaries. Because what is the point of, even in theory, having that kind of independence in terms of, operational independence, and then financial independence or autonomy at the federal level being theoretically enjoyed, and even in theory, it's not so enjoyed at the state level. I think that's actually the crux of the matter of the strike. So what is the point of having state governors, controlling and reducing state judiciaries into destitutes and beggars, going hand in cap for practically almost everything except their salaries and emolument. And second, at the state level, you also have a huge crisis that have been lingering for over 2 decades, to the best of my knowledge. The Magistrate Association of Nigeria, I know of, in the early 2000 and 2001, for instance, they had series of meetings with state judiciary, with state CJs, on the need for them to move away from the classification as civil servants, with paltry sum of 30, 40, 60, 70,000 naira, for a senior magistrate or chief magistrate in some states, and to date they remain civil servant. So, and the irony of it all is that this category of lower judicial officers, that you can call them, magistrate, Sharia court judges, district or area court judges, and customary court judges, that are not superior courts of record, judicial officers, they handle actually 65 to 70% of all our cases across the federation. And yet, what they get actually is a paltry sum, and yet they can't even be properly classified as judicial officers. They are treated like civil servants because they are actually at the state level seen as civil servants. And so there is no professionalism in the classification. That is one. Second, the remuneration is not actually commensurate with what they do in actual practice, handling almost 65-70% of all the cases before it gets on appeal. And you want to fight corruption in the judiciary, and then you can't even address the classification of such lower judicial officers. You want to fight corruption in the judiciary, and you can't even address, the package, the basic package, and emoluments actually of this category of judicial officers. You obviously actually are encouraging corruption and abuse of power, and yet we call the judiciary, as the last hope of the common man. How and in what context? It makes no sense. So I think if our policy and decision makers are serious about, judicial reform, these are some of the issues, that need actually to be addressed. You can't actually expect. I think it's very shocking today for all of us to actually hear, because for many years people thought that our appellate court justices were earning actually some millions actually of naira in terms of their take-home package, but it's not true. And if you set it against inflationary trend, as at today, and the most actually serious actually concern is that since 2008, when the review was actually made, no such review was ever made, in almost 12-13 years. So their package remained stagnated, at that level. And it's not good for the system. It's not good in combating corruption, and you also want them to give their best in the system. And I think what also obtains, at state level, is also why you have Executive Order 10 of 2020, that seeks to actually provide a basis for, judicial actually autonomy, particularly financial autonomy at the state level. But it requires an implementation guidelines, for the justice sector actors, including state governors, to understand how to implement the executive order itself. And this is actually another actually big issue that we need really to bring all stakeholders on board, post this webinar, to find a way actually forward. And I think the last point, that I believe strongly the Judicial strike has also sent a signal to all of us is that, for a very long time, they've been actually quiet and silent, and they've been suffering actually in this regard. But I think it's very, very unfortunate that the strike affected largely litigants, some of whom actually are very poor litigants, expecting, the cases to be disposed of within a given period of time. But it never did. And I think, like the lead speaker said, the least we can do from this webinar proceedings is to probably tender apologies to those litigants. But I think apology is not enough. The relevant stakeholders, National Judicial Council, Nigerian Bar Association, Office of the Attorney General of the Federation and of the respective states, in the Federation, and the Attorney General of the Federation's office, all actually need to really understand the problem that the judiciary actually is facing. It's been a very wrong perception that they are essentially autonomous, probably operational wise, but certainly not in terms of financial autonomy. And I think this is where quite a number of relevant stakeholders need to actually understand and then make their necessary input so as to move the judiciary away from financial bondage and to also provide what is also called remunerative respectability for the judiciary, and that is very, very important. And I see no reason why state governors cannot amend their existing laws to reclassify magistrates and other actually lower court actually judicial officers, as judicial officers, away from actually, being typical civil servant. And I think this is actually one way that they can surely attract, some of these actually very good, brainy lawyers to join the judiciary at the state level. Otherwise, they will continue to actually run away from the judiciary in that respect. Or you recruit people with the mindset that they are actually going to turn it into a gold mine, and therefore they will actually abuse the system and also corruptly enrich themselves at the same time, and that will in itself destroy our democratic actually effort in consolidation. It will also affect the fight against corruption, and that will also not necessarily also make the last hope of the common man, so-called, always to really be seen as the last hope of the common man. And I think what we intend to do after this webinar is to package the proceedings and then draw out some policy recommendations and issues, and then probably engage further the relevant policy and decision makers, to see the need for further actually reform in this context. Thank you very much. Thank you.